By the beneficiaries who are what? Okay, and by the courts, what? What the case was? What tell us about that? What the court? No, the case for the court. Would the court tell us how to? What the case is for the court? With the court in the court's inherent jurisdiction. With the tree, with the kid, right? Yeah, would they set out how you? What the three factors? It was three or a little bit more. What the court will do, and it's in there. Why they will do it? Just a little revision we could do in the same instance. What it could do? Just the court's inherent jurisdiction. Anybody? No one remember? Why how the court will replace or for the what we say first? Look on page 45. That's section 48 of the Trustee Act. What the court will do? Or the jurisdiction of the court, which was dependent on the party. In the interest and welfare of the beneficiaries, actions of the trustees if they are acting improperly or dishonestly and endangering the trust asset, and the nature of duties to be performed by the trustees and whether such duties were of a particular personal or delicate nature. So the court will step in, eh?
What section is it?
This section 48 of the Trustee Act. What 47.2 says? We just do 47.2. What that say? The trustee may retire by an express clause in the trust instrument under section 47.2 by the beneficiaries or by the court. And then it goes on to tell you how, why the court will step in. Yeah. So a court will discharge. A court will discharge a trustee provided there is at least one other trustee who will continue to act as trustee, or a new trustee is capable of being appointed to the trust. This equitable principle is to ensure that the trust continues to operate in the best interest of the beneficiaries, taking into the consideration the nature and extent of the trust. So the court still have to look at all these things to make sure that they're not disadvantaging the trust by discharging the trustee, because the beneficiaries may just want him to be moved for their own person, and the trustee may just want to be discharged of his duty. Say, I finished with this, but then the court will say, let me look at all the surrounding circumstances.
But in every case, though, you always have to have at least two trustees remaining, right? Unless it's a.
But remember, right? You have to have a next one if you're trying to retire. Otherwise, it may only be one. But if it's a corporation,
that can continue. But if it's only one,
right?
We can't have one.
You just can't just say you retiring and nobody's there to be appointed in your stead. So then the court will have to intervene, eh?
And then they could appoint a new trust, right? Or
the court. Or who else could do it?
The beneficiaries. Or the trust instrument.
Express clause. You see? All right.
A trust instrument may contain an express power which allows a trustee to retire. Additionally, there are provisions in the Trustee Act 1998 which also permit a trustee to retire. A trustee may retire by obtaining the consent of all beneficiaries who are sui juris and between them absolutely entitled to the whole beneficial interest in the trust.
Well, who we talked to about this? Who this was? Yes, McPhail does it. Okay. Another way?
Another way for a trustee to retire is to obtain the consent of the court.
That's who? Who that case is?
Sui juris means what again?
So they, no, sui juris, what they are.
They agree. They have mental.
Yeah.
Mental.
Yes,
Okay,
yes,
I
yes,
agree.
yeah.
And they all agree.
Yeah.
Okay.
So right, so they have to be of a age and sound mind.
Another way for a trustee to retire is to obtain the consent of the court.
Which case was
Which case that is? We just said that's your favorite case
Oh,
for the consent of the
turn
trust.
around,
Yeah.
we turn around.
Okay.
A trustee who seeks to obtain the consent of the court to retire from a trust will be required to pay the cost of the application for such discharge, except in the instance of where he has demonstrated to the court that the trust has changed significantly from its initial appointment and or acceptance to act as trustee of the trust.
So in other instances, if he applies on his own just because he wants to be out of it,
That's one thing.
he got to pay the cost of the application. But if it's something that he could show, will this change from? I was supposed to be managing this, but they putting all kind of things. I don't know what's going on behind there. I don't want to be involved. Let me get out of this. But he have to prove that, eh? Mm-hmm.
A retiring trustee of the trust normally requests a release from liability in relation to his trusteeship, which he may be granted on termination of the trust. Where a new trustee.
So you see, they say he may be granted. They may not want to, eh? So what are you gonna do in that instance?
may or may not be granted.
That's true.
Because once they say may, that ain't mean.
That's not shall. So if they may grant it, what he'll do if he don't want, he may not want to move any further. Eh? Since I can't get it, I don't want to do this trust anymore.
So what
Because
happens?
whatever you do, so look for another trustee, but not me, because they said already do garbage, and you ain't gonna hold me accountable for that.
So retiring from a trust that's like retiring from like a regular job, but that just means that you done dealing with this particular trust.
Right? They don't
You
want to
know what
deal
you
with
was-
right.
And you could go and manage other trusts.
Yes, because he's just coming out of this one. Hmm.
But if it's not granted, what does he do?
So that's why he's gonna approach the court. Eh? Hmm.
So if he decides to pursue that, he would have to prove or whatever. Where a new trustee is appointed upon the retirement.
Now this, remember, this one is where the retiring trustee, he wants a release from liability in relation to his trusteeship. What that means? You retiring from this trust.
And the new trustees coming in.
So what kind of what I could release you from? Only from this point forward, eh? From when I take it over.
Right.
But you can't expect me to release you for whatever you do before.
No, you're still responsible for what
Right.
you do before.
So this what this is, what that is, the what? What we looking for?
The
No,
indemnity,
right.
indemnity.
Yeah, the deed of right, the indemnity. You see how everything keep coming right back. So now you're all getting the full
trustee
check.
would have to examine the deed of indemnity and make sure he's covered.
No, the old trustee of anything.
See, the old trustee wants the new trustee needs an
new trustee,
indemnity.
Yeah.
But the old trustee wants an indemnity from this point forward, from I retire.
Both of them want one.
Yeah.
Yeah.
So you
I want
releasing
one to
me
say,
from
I'm
anything from this
responsible
point?
from here on in. And
Uh-huh.
she's saying, again, I wasn't here prior to today.
So when you get a mortgage, what happens? When you pay off your mortgage
You get a
and you
letter
selling
of
this,
satisfaction.
right? So you selling this property to me. What happens? What I want? But I want you to satisfy everything up to the point I take it over. I'm not responsible for your whole real property taxes, all your water bills before this. Up to this point, one of the requisitions we say is give me we need a plain real property, zero balance for your light, your water. Now anything going forward, make sure my name off it so I go right to who? As the old person who owned the property, I write into BEC, I write into water and sewage, I write into
Yes,
inland.
yeah.
Yeah.
Oh, I thought you just was go tell BC to put it in your name.
No, you right, because
But
you
just
don't want to be
remember that
liable.
They're not gonna just transfer it over because you say so. They still need some validation.
So they could carry your conveyance to get the lights turned on, but then they could be operating under your name. So that's even with your
Yeah, but then
cars
they
now.
would just, I thought like with light bills, they just would always have, that person will always have a bill under their name.
Right, but that's under my name.
So they write to BEC, but their bill doesn't necessarily have to be the zero, but they could just write to BEC saying that they don't reside in that
No,
particular pay.
I am the purchaser.
Mhm.
Before I purchase it, I need a zero balance from you at BEC, or else that will come out the proceeds of sale. I will satisfy that first before I pay you your money.
You
Me,
can't inherit none of your debt.
no, I'm not.
No, but I saying I didn't. BEC don't transfer debts to names. You just.
That's the
But
owner of the
even
house
BEC
now.
don't
Remember,
transfer names.
that's the owner of the house.
But they would.
They keep a
always just keep
conveyance.
that running bill in that person's name.
Right, but what happens is it attaches to the property. So eventually, if your name's still on that and your bill carrying around, they will come and move that meter.
Oh.
And that's where you will be
Yeah.
affected.
See, I'm the new owner,
Mhm.
but your name's still on my light bill. You see, your name's still attached to this property. So they come in there and they can move that meter.
Gee.
Yeah. So even with landlords, some landlords have owners meters and they've not been paying their bill, so the tenants can't even get light in the place because you've not been paying your bill. Until you satisfy that, none of your tenants can get light in here. That's
Even if a previous tenant would have run the bill up and up, right?
well, the previous tenant causes your deposit to increase, but that's on BC if they allow. That's why you want to make sure to separate. No, well, this only a tenant. This is not the owner. You see, so ownership is different than you being a tenant.
So both of the trustees, the incoming and the outgoing,
So one is the
Right together.
vendor and one is the purchaser.
right.
So the salesman want his things to clear off up to the point where he leave it, and the new owner wants you to make sure don't give me none of your old bills. Yeah, you see? Okay.
Okay. Where a new trustee is appointed upon the retirement of the trustee, the release from liability may not be granted depending upon the circumstances. Removal. The court may also remove a trustee where he is unfit to act, refuses to act, incapable of acting. The court can remove a trustee without replacing the trustees. See Letterstead versus Perez.
So what happens in that instant? You'll get letters that I send you all that.
I have a question to the back of 1 minute.
Mhm.
The release from liability may not be granted depending upon the circumstances.
Yeah,
Why wouldn't it be granted?
release from liability, cause you in trouble out there. How could I release you from that? That means I'll absorb that. So you owed BEC 500,000. You made an agreement to pay it. I go release you from that? No, you
But
continue
will take it
paying
off.
that. Yeah, I'm a new owner.
But
That's
so they will leave the liability under you, but they would still release you from being a trustee.
no. You are they're releasing you. You retiring. But in order for you to retire, you want this liability to stop. I don't want you to continue with my name on there to make it seem as if I'm still a trustee. So I want something to show that I've passed over and you've given me a deed of indemnity against anything moving forward.
But
Likewise,
you don't have that, so you're still liable.
no, that's not for that. On retirement, the release from liability may not be granted depending on the circumstances. That's past, but going forward, you can't hold me liable for what you're going to do.
No, going forward, you won't
Yeah.
be liable.
Right, so the
But
person would always
they're not
be
giving you a
liable
release for the
past.
past.
Who's not giving you the release?
Um,
You mean the retiring trustee?
Yes.
So now what you gonna do? You approach the court, to let them know if you decide to take it on, but you make it clear that I've researched this trustee has done this, and now because if you take it on blindly, that's on you.
You accept the
Yeah, you accept the liability. So you take the benefit and the burden. You see? You need a release, It may not hold as much water because
yeah, need
you
the
should have
release.
done certain things still. and insured. So if something is brought to your attention, you let the beneficiaries know. I realize this trustee didn't do this, and the next thing, and I only come to know it now that I'm able to do a little bit more digging. So let them know right up front and let them deal with it, or else I will have to step away. But you can't hold me accountable. But that's why you have to be what? As a trustee, which is, yeah, what else? You have to make sure you know your trust. You have to know all, which, so you need to know the clauses, what's supposed to be happening. Yeah, you see. So you have to be a real trustee, so you don't hold the bag.
The removal of a trustee by a court is normally based upon the actions of the trustee, which may be due to some dishonesty for which he may have been formally convicted, or some financial irresponsibility with regard to property under his trust, or by him becoming a bankrupt. A court may also remove a trustee from a trust where there is found to be continuing friction between the trustees and the beneficiaries. Example, for substantial overcharging by the trustees, and the fact that the trustees may have a difficult task of administering the trust in the best interest of the beneficiaries if left to continue to act as trustees. Leatherstead versus Broers, 1884. In the case of Wiesel versus Chase Manhattan Corporation Limited, 1994 Supreme Court, the Bahamas, number 1261 of 1992, unreported, the court suggested that to remove the trustee, there should be proof shown of some misconduct or mismanagement of the trust assets, and not merely that the beneficiaries are unhappy.
So they're not going on your feelings, eh? There's a contractual relationship, eh?
But if somebody say name and do something wrong myself, let them go. But saying they do it properly.
You mean that's no? This when the beneficiaries will move him.
Beneficiaries will get rid of the
Oh,
trustee.
if they being evil.
Yeah.
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 This trustee or these trustees do.
Yes, because now they're not going with whatever their bidding is. So they saying, "Man, get rid of him. Let me get somebody who listen." Yes.
In this case, 4 of the beneficiaries sought the removal of the corporate trustee, as the company did not sell the 49% interest in the partnership as directed by the settlor, who was given power so to direct in the trust instrument. The discussion centered on the trustee's standard of care, Spate versus Gaunt, in which the judge stated that it is not indeed every mistake or neglect of duty or inaccuracy of conduct of trustees which will induce the courts of equity to adopt such a curse.
It's a course, yeah.
The acts or omissions might be such as to endanger the trust property, or to show a want of honesty, or a want of proper capacity to execute the duties, or want of reasonable fidelity. The court held that it was in the best interest of the court to remove the trustee, as the trust had 6 years before it came to an end, that the asset had been liquidated and dispersed to the beneficiaries.
Okay, so when they remove the trustees, what they want?
The co-op, you mean?
What they telling them
The
to?
close of the trust.
Only 6 more years to go on this. Let's get rid of this one time. There's too much friction going on in here.
So in this case, they close out the entire trust.
Right, and so what happened? What the trustee wasn't doing? What he didn't do?
He didn't do what the beneficiaries wanted. I mean, the settler.
So the company did not sell the 49% interest in the partnership as directed by the settler. Because what kind of trust this was, or what? What we say this was? Who this is? What the settler doing? He said what?
He's a power holder.
So what this kind of trust this is? Director. He directing it, eh? So he was given power so to direct in the trust instrument, you see?
So, trust could be set up, so I could say I come to set up a trust for 2 years, 3 years, 5 years.
Well, you set it up with a period of vesting, so something's gonna happen that causes the trust to come to an end.
Like
So
nowadays have King George's
yeah, lifetime, his last child, whatever.
last child.
But you may have it to say when this child turns 18, everything could. You see what happened in McPhail?
Yeah, McPhail was the one with the when he became 21.
Yeah. So they what
Mhm.
happened?
21
Yeah.
hours, yeah.
You see.
But it was supposed to be for when he's 25.
Right.
Yeah,
But
that's
they.
okay.
Mhm.
And he was like, he could wait and see.
But what they said could have happened because he was what?
He was surgery.
Absolutely.
But
Mhm.
then they had an amendment to stretch the perpetuity.
Yeah, that's what I sent you on.
That's it. Yeah,
They-
so
they-
so it can be unlimited now, right? You can just go
Mhm.
on and on and on. And
No,
on.
it still have a
It's
time.
180 years.
Yeah.
It's 150.
158.
150.
And plus 21.
years.
Yeah.
Gestation.
It
Yeah.
went from what? Because our legal counsel,
Mhm.
she was
It
showing
was
me,
88.
she was going over the parts of a trustee with me.
Mhm.
She was showing me
It was
it used to be gone from like
The
60
king, they
to
still use
80,
the royal family as the
Right.
thing, the
or any
last,
bloodline you
right?
could trace, right?
Yeah. So they move it, they keep moving it, and now they get a little bit more time. So now the ones that are after, remember we did that. The ones who were before the act change, what they have to do?
You have to apply to the court.
Right. Yes. Remember that now. Okay. You gotta read couples. Give her a break.
This is like the last paragraph or something.
But you gonna read the last paragraph, huh?
Yeah. Additionally,
Additionally, the decision of McPhail v. Dalton reiterated the principle that if trustees are unable to administer discretionary trusts, the court could appoint new trustees to do so. A trustee may also be removed under a power within the trust instrument or by statute. Circumstances surrounding the removal of a trustee under a power within the trust instrument must be clearly related to the power of removal, since the power will often be strictly construed, and the removal of a trustee may impact negatively on the trustee from a moral standpoint.
What's gonna happen to the trustee? What you doing with him when you remove him? And what you causing his what you right. Okay, we could do the questions now. You still have okay, a trust instrument. You don't have the book. You can't. We'll go in the back. What's your name? What's in it? I have you on the list.
you want me checking for the
No.
list?
Okay.
You want me checking?
Yeah, you have one. You just starting now, eh? Yeah.
I just sitting in right now.
Okay. You have your book? Yeah.
Yeah, this is another one, but I'll try.
Okay, number 1.
A trust instrument may contain a blank which allow a trustee to retire. That's the question.
May contain a right.
Shall be expressed power.
And we will find the answer.
Page 59.
59. And which paragraph?
Paragraph 1.
In the same unit 8.
Mine
Oh, yours
First
different.
paragraph.
It's the first paragraph under retirement on our unit 8. You have that one?
First, a trustee instrument may contain an express power
Yeah,
which
that's
allow a trustee to retire.
Right.
Additionally, there are provisions in the Act, in the Trustee Act 1998, which also permit a trustee to retire.
Right. Okay. Number 2 in the front, Sanders.
What are two other ways in which a trustee may retire?
Now you have to tell us what page to look on.
59. A trustee may retire without a replacement if there are at least 2 trustees or a trust corporation who may also retire when the existing trustees consent to his retirement, or the trustees may execute a deed of retirement.
Okay. That's 2 other ways. We have 3 there.
Three.
They gone into it a little bit more. What happens then? What's the next word?
Where the requisite consent cannot be obtained, the court has the inherent power to discharge the trustee without a replacement.
So they only ask you for 2, but we have 3, eh? Okay, next. You have your book? No way. Okay.
No. But it say a
You
court
want to hold
will
on to that?
discharge a trustee blank or a new trustee is capable of being
could say
appointed to
that.
the trust.
Where we find the answer?
Page 59.
Page 59.
Yeah, it looks like the third paragraph.
Mm-hmm.
So,
And what's
is-
page 59 at paragraph 3?
Will provide there's at least one other trustee
Court will
who
discharge
will
the trustee.
continue to act as trustee. And the trustee is capable of being appointed to the trust.
This is still the retired one?
We still in retirement yet.
Are we still on 2?
We on
Three.
we on 3.
It probably should be something like if it's
Look on page 59, paragraph 3. What it says.
but paragraph 3 the court will discharge a trustee provided there's at least one other trustee who will continue to act as trustee or a new trustee is capable of being appointed to the trust.
Yeah, that's the answer. The court will discharge a trustee provided there is at least one other trustee who will continue to act as a trustee or a new trustee.
Suppose there isn't one.
Oh, that whole
Yeah, I don't mind a little line.
Yeah, the lines are
Yeah.
all for that.
Yeah. Huh?
Suppose there isn't someone, there isn't an ex trustee.
Provided there's. So what happens then?
Oh, a new trustee.
What they say could happen.
Oh,
What we,
you would have a new trustee capable.
what they say? What if nobody could do? What the case is?
The court appoints.
Sure,
No, what the court will. What if we don't have somebody to appoint? What the case is we just said with the L?
Letters.
Yeah, what Ladistell and Browse say?
Straight out, the court may also,
What they say about it being that he don't have to be in there. Look at removal.
It's a court will also remove a trustee that is
Continuing friction between the trustees and the beneficiary.
No, the first one on the removal. The court can remove a trustee without replacing.
Refuses.
What the court can do, remove a trustee without replacing it.
yeah, it say that. The court can remove a trustee without replacing.
And that's your case. Y'all had a little while now. Y'all must be done read that one back and front. And right there in your little
So
thing.
what happens to the trust?
in which little thing?
The trustee that court is removed, basically.
in what, in this?
Look in your first one is Ladistell.
So if they remove the trustee without appointing a new trustee,
What that means?
that means they just give the beneficiaries their shares of the funds and.
No, what gonna happen? Who's gonna now? If I remove you, then what happens? I'm the court.
You'll appoint a new one, eh?
No, but if I don't want none, so what happened is a what? Court administered trust, eh?
The court can administer the trust.
Yeah, so now the court will now have a what? What happens with the case? So no, the court is not gonna be the one who's doing it, but they'll have somebody now.
Appointed.
Yeah, to now. It wouldn't be a trustee, but it'll be somebody who will have to come to them every time for direction.
So that's a court appointed trust.
So it's a trust. It will be like a.
Administrator or something.
No, it's under court appointment, so it's the court directing what's gonna happen with the trust. So they may just decide to what.
I thought they just close it
Close it
and
up.
just give the beneficiaries.
No, because then
No,
some
they might-
things
they
may
might
not have
get
happened
another-
yet. Yeah, until they probably find somebody else.
Appoint that person as a director.
So they usually have receivers
As a
in
trustee,
companies,
sorry.
so they may
Appoint that person
what?
as a
They may
trustee.
use.
So is that more like a constructive type arrangement?
No,
Not really.
because constructive means you reading in between, or resulting happens as a result of something else.
So
But
what is a
let me
court
tell you.
directed trust court?
So let me tell you, you will just notice as a matter of course, but you wouldn't try to incorporate it in what you're doing now because you'll be going off on a tangent. You see. So I'll send you that information.
But in every case, what I'm still trying to get though, when it's not a corporation, not a corporate trustee, but let's say a few people. Is it where there always has to be at least two trustees? Even if someone retires or they remove themselves or
In order for you to retire, you need what? They said you should have what? Another trustee.
replacement.
Right.
But what if you can't? I mean, like I know stuff has happened. So what if you can't find does that mean you can't retire if you can't find a replacement?
No, so what you could do? Yeah.
Also, you could go to the court.
Yeah, but remember what we say: if you go to court, we're gonna happen.
You have to prove that.
Otherwise, you're gonna do
you have to
what?
pay for it.
Right.
It's hard for me to retire.
Yeah. Because you go on and take on this job now. You want to know,
I almost there.
No, sometimes they just don't want to be there.
Sometimes they.
That's a good way to put it.
It sounds like more intense than a marriage, because at least you can get out of a marriage.
No, you can't get out of some marriage.
Marriage you can't get out easy.
No.
What? That's for real.
Wow.
Because somebody may not want to be divorced from you.
They can make you
What you mean? How you don't want? What you mean?
Well,
you
the
don't
court
want to be
will not
divorced?
give you the divorce if you can't.
Yeah, I'm talking when you go for a divorce, the court is also going to have you put y'all up together. And so you got to now figure out how they're going to share it up and who's going to buy each other and all that sort of, who the children involved and
Some people
who's
is
going to
staying
pay
in that misery
alimony. So
just to.
Yeah, they don't want. Because then the whole house broke up.
If you just want to go, they will say, okay, fine.
No, because then you'll just use the court like like a barroom door. You walking in and out. Now marriage easy to get in, hard to get out.
Some people is
It's like
do it
trouble.
if
Yeah.
two y'all agree to it and you would be like, okay, I
Y'all
can
can't
do the
agree.
house and stuff. I guess you would be able to do it like that.
Now y'all can't go to the court and say we agree that we don't want to be married no more. You can't tell the court that you condone. They ask. That's one of the questions. Have you condoned or connived? Is this in collusion with each other?
They might just say we don't want to be married.
So
No,
what if
that's
they
not
don't
a
want to be
ground.
Why
married?
you can't?
That's not a ground.
What type of
The marriage is a
democracy?
contract.
Yeah, the grounds are adultery, desertion, or cruelty.
What about irreconcilable differences?
That ain't over here. We in there.
In states, they have that
You
all
could
the
try
time.
that over there.
Everyone, that's
yeah.
the main reason.
Yeah, but we supposed to be a Christian nation. Yeah.
Right. So our principle is completely different from
Yeah,
theirs.
and
They're
so
trying to make it hard so that it wouldn't be so easy.
Especially
to
when-
yeah, and you're supposed to take it with the seriousness it is supposed to be taken with. But
America got everything for a play.
Some
You
people
pay your
get
way on
divorced,
anything
but
away.
Lord, divorces be expensive too.
divorces could be expensive if they get nasty. But sometimes people don't kick up no fuss. They end up nothing.
That's the same way how if the trustee wants to
Retire.
remove from retirement. This is
He gone in that contract.
yes, this is
That's his
something
little
that
marriage.
too. So that's why I call it a marriage.
Boy,
That's a good
yeah, that's a
one.
good analogy. 'Cause
Mhm.
afterward, I think in our reconcilable differences, yeah, I just want out, leave me alone. Why?
Really?
Yeah, I know at the stage you could get a divorce for that, and it ain't no long story either.
Yeah, but
But
over
here
here,
it's different.
yeah, they more stringent than that.
Yeah, but the same stringent rules apply with the trustee. Yeah, just get out.
No, because you're going into some contractual relationship. All right. Okay, let's go to the next one.
Request a release from liability in relation
Freedom indemnity, right?
What we asking them for? What it is? Where we find the answer? Look on the page.
in the last paragraph.
That's number 4.
request a release from liability in relation to his trusteeship, which he may be granted on
That's the
termination
deed
of
of
the trust.
indemnity there too, right? That's the same thing, right?
So he want a release.
Mm-hmm.
He wants you to release him from all liability. So he wants to be what? Indemnified. Number 5.
I don't know. You gotta understand. I studying this to want to do this, you know.
Okay, with
I just
regard-
supposed to make me want to do this more, you know, not
Yeah,
laugh.
yeah.
You're doing less, right?
Y'all help me out, guys. Number 5, with
Yeah,
regard to the
yeah.
removal of a trustee, the court has blank jurisdiction to remove a trustee and appoint a new
Allison? Yeah.
trustee to replace him or remove a trustee without replacement. So with regard to
That's one we just, I think that's part of what we just read.
has what jurisdiction?
What it is? No, what the court has?
Court has blank
Jurisdiction to remove a trustee,
and appoint a new
new trustee to replace
trustee
him
to
or remove a trustee without replacement.
Mhm. So what kind? But they have what kind of power they have?
They say blank jurisdiction.
What that is? What we already know what it is. We keep saying it.
That's
Chalaram, but Chalaram said the court out.
Jurisdiction?
What kind of jurisdiction it have? Inherent. We all remember that word every
Yeah,
time.
inherent power.
So it right here, where the requisite consent cannot be obtained, the court has the inherent power to discharge the trustee without a replacement.
Which page?
That's the same as
That's page
inheritance
59.
jurisdiction.
Paragraph 2.
So it's inherent power, right? I have
It's inherent
Ah.
jurisdiction. There's power, it's the same thing.
Oh, okay,
Mhm.
okay.
Number 6,
So tell around and then,
Chalaram tell you about this inherent jurisdiction. Right?
so inherent power, inherent jurisdiction is the same thing.
The removal of a trustee by a court is normally based upon the actions of the trustee, which may be do some blank for which he may have been formally convicted, or some with regard to property under his trust, or by him becoming a, I know this last one is bankrupt. right?
So where we get the
Dishonesty,
answer?
That's page 16.
What paragraph?
Some dishonesty.
Right.
Right.
Mhm.
So due to some dishonesty, or for which he may have been formally convicted, or some financial irresponsibility with regard to property under his trust, or by becoming a bankrupt.
Okay, next one. We get that one. Next one.
What are two other ways in which a trustee may be removed from a trust?
Right next. Next paragraph.
Continuing fiction, this one's a continuing fiction.
Mhm.
With the beneficiaries and removal under a power.
Where we can find the answer? You have to tell us.
Paragraph 3, page 60.
What's that real on
It's
7?
not, but we're quite.
We on number 7. What are two other ways in which a trustee may be removed from a trust?
If you have,
That's the same question as question number 1.
What question number 1
if you
say?
have, fiction between a trustee and the beneficiary is one.
This one.
And then you have the difficulty we address in administrating the trust.
Where that is? Where we
In
find
the
that?
best interest of the
In the
beneficiary.
best interest of the beneficiary.
And
If
he's
it's
not
in the
a
best
thing,
interest
yeah.
of the beneficiary is to remove the trustee.
So, and who tell us that already?
Court,
Mhm.
page 60. Third to the last paragraph.
My book is a little different. I have
No,
a
that's
copy
saying
also
it a little
of the
different. That's say under fact that the trustees would have
So
difficult tasks when administering the trust in the best interest of the beneficiaries.
So it's two. What the two things is?
The
Should have been fixed between
And
the trustee and the beneficiary.
and the next one.
And the next one is then and the fact that the trustee will have a difficult task of administrating trust in the best interest of the beneficiaries.
We have left to continue. You see it?
So that's basically just like he ain't doing it properly, or he ain't.
Right, he's not doing a proper job. Understand.
Okay. But a court may also remove a trustee from a trust where there is found to be blank between the trustees and the beneficiaries. We just answered that. What it is?
Now, where did we find our second,
Right there. Right on the same where we going now. Third paragraph under removal.
Friction.
Yeah, for sure.
You get it? Y'all get it? Hmm? Everyone have the answer? Yes? No? Maybe so.
Friction. Some of them.
Sanders, you have it?
Yeah, that's all I do.
Which one you want? Which one you want? No, 8.
Uh-huh. Yeah, friction.
You want 8? Okay, where we find 8? Where we find 8?
60 paragraph 3.
Yes? Everybody know where that? You writing our answers?
No, I'm practicing something.
Alright. Number 9, if trustees are blank or discretionary trust, the court could appoint new trustees to do so.
What?
If trustees are blank or discretionary trust, the court could appoint new trustees to do so. Would we can get that? Where we find it?
Page 60,
Discretionary trust now. Look right on the second to last paragraph.
right, right, this is, Phil and Dalton to do
Reason, unable to administer
A discretionary trust.
could appoint a new trustee to do so.
Mhm. Okay. Next one. Last one.
the circumstances surrounding the removal of the trustee.
Oh, we got it.
Even the constitutional must be power removal. So it's the power.
Where we find it?
That's the last paragraph, page 60.
Last paragraph, page 60. A trustee may also be removed. That one? Where we looking at? The circumstances?
Yeah.
That's the second sentence in the last paragraph. So we have everything. So let's answer a few questions and then we could go. I know it's a long night.
Our last class was due Saturday. So could you go over some of those I think you had some questions here too.
So I could send you all these questions and we could go over these too, so we can make 9 quick, 8.
When you go like the day month and stuff like that, that's what
Okay.
the mortgage and stuff like that, but just Saturday we read too. Because I think your question with the differences, but maybe to understand that a little better.
Let me, your paper there, please.
Okay.
That register, please.
Now, that's my email right there. I write on that.
S-T-A-I-T-T Johnson.
Is this recording?
Oh, we could cut that.
My head all up inside that.
You started.
Oh, Lord.
I'm missing one person. I have Carey. Who else? I have Wells, Thompson.
What the girl them who work the Commonwealth Bank?
Oh, no, the one who worked the
Another one who
insurance
said-
company.
Another, yeah,
Shido.
the response or something like that. The one who.
Yeah, I don't know. I don't know if you're on the right hand side.
What's her name?
Name Yasmin.
Okay, I have Yasmin. I have Carey. I have Sanders. I have Wells. I have Thompson. Valeria. I don't have you. That's the next person. 3, 6. Yep, that's it. Okay, I sent you all the questions. Okay, what y'all wanted to review quick? You want to review, or you want to answer one of the questions I just sent? Let's answer one of the questions. Describes how trustees can retire and be discharged from their duties. That one we just finished.
They can apply, they could, have a deed of.
This, so describe the statutory power to appoint additional trustees. Where we find that?
Describe, what is it? Describe the statutory.
Power to appoint additional trustees. Where we find it?
Chapter 8.
Appointment. This retirement and removal. What we did? We did appointment, yeah? Remuneration. You want me to do appointment? We did that somewhere.
Yeah, we did appointment. If it ain't in chapter 7, it's in chapter 6.
Yeah.
First one we go on.
So what we'll answer in this instance when we doing that one? Appointment, what we'll do? Or you all have some other questions, y'all, because you all sound like you all don't want to answer that one. Tell me something what y'all want to answer, or what y'all want to look at.
I was asking you to go over what was I was trying to find the chapter, the bailment and agency and
Okay,
the bailment was just with chapel and or something.
okay, let's see. This is the classification of trust, that one? We have constructive sham trust. Bailment is on page 31.
Yes, page 31. An agency. Bailment and trustee fee, even though they appear to be similar, bailments could only be made of chattel.
And what chattel is?
That's like cars and their possessions and
Yeah. And what happens in bailment?
Somebody's holding it for you.
Right, and so no legal title is transferred, right? In a trust, the trustee has legal title. You see, that's the difference there. Trustee has no rights but duties and obligations in dealing with the property. So they have similar characteristics, but so bailment is basically just another relationship, but it's nothing of what?
for the trustee level to make.
They have any
higher-
legal right to the property? No. You only holding this on my behalf. What about agency? We have plenty agents all around. You all have insurance agent, this, yes. So principal agent.
Nature,
Mm-hmm.
Who represent the principal, that's all they speak on behalf of principal and they act on behalf of principal, but they are not the principal.
Right. The beneficiary has equitable interest in the title, in the property. What else y'all have?
in contract, I think it's right of personal obligation.
And I think you should know the difference for those multiple choice questions when you have to say what's the difference in trust. You see how we had those questions when you had statutory trust, they may give you a definition for an express trust, and it's only a multiple choice, so that's just a quick answer. So you should know the differences, what the differences are in the trust. You see, they gave you. Remember, we did some multiple choice on this. I gave you all some multiple choice on it.
That was another question.
Yeah.
So.
Appointment of trustees is on page 44, section 42 of the Trustee Act deals with that.
Be so wounded without this book.
Mm-hmm. So we could answer that question with that, eh?
This question you gave us?
The statutory power to appoint different additional trustees.
Contained within the trust.
Identifies 3 qualifications to the general rule concerning trustee remuneration, but we'll look for that. Remuneration.
Remuneration and what? Chapter 6? Chapter 5 or 6? 7?
We just do remuneration.
Lately?
Yeah, we do it with 7, eh? Because that was 7 is remuneration. What 3 qualifications to the general rule concerning trustee remuneration?
Must be the trustees.
What the remuneration for?
To make sure you get paid.
So who could give us? Who could give us?
The courts.
The courts. Who else?
The settler.
Trust instrument and the beneficiary.
Who are what?
Soldier.
And
Of sound man. Oh, okay. Well,
okay. Oh, don't cut off. All right. Identify the factors considered by the court in assessing trustee remuneration. Where we gonna look for that?
that should be in the same one. Unit 7.
Yeah, where we gonna look? Which case we looking at?
I got it. The cases there.
Page 55. See, so y'all could answer these and just get it right out of the book. What 55 tell us?
There's some new questions you said.
Yeah.
What the one is?
Identify the factors considered by the courts in assessing trustee remuneration. $55.
The protection against claims of the trustees, particularly in light
So
of the
what case we looking at?
Duke of Norfolk settlement.
Yes. That will help us to answer that question. Discuss the rights of the trustees to be indemnified out of the assets of the trust. What that is. Discuss the right of trustees to be indemnified out of the assets of the trust. We just deal with that in remuneration too, right? What we said. Expenses, liabilities incurred.
Right, they can deduct that, they can use trust funds.
And what we have, is it in the trust document or
No.
it's in the act?
It's in the act.
It's in the act to show up.
What section we dealing with that one?
So
What we said, where it could be indemnified. What that was?
so this ain't the whole lot.
Hmm?
This thing right there, this ain't the whole lot.
No, you have to get 98. That's only something.
So where can you get the full one from?
You get it. Look for 1998. It's the amendment.
I saw the 1998 one, but I gone straight past it.
Which year that is you on?
That's
It's
2011.
2011. It's only the amendment.
Oh, you mean 1998, big one.
How big that is?
Big. It's size of the book.
Remember we outlined that?
That's 1998. Yeah. Fine, but
It's like 99.
that's alright. PTC good for us. Got that one.
Where we going? For that one?
Maybe one for that one.
Mhm.
What was the case?
Bluff.
What was the case for the remuneration?
Duke?
Duke. Duke of Norfolk settlement.
But this one is on top.
Hmm?
This is on top.
This
That's me?
so.
That's why you got it.
Y'all get it?
You can't find it. Yeah, how the chapter there's the remuneration.
7. That's the one we just did. I take a look on what?
I have that.
That's the total.
We looking now for what? What we looking for?
Remuneration
What we looking for?
Remuneration.
regarding remuneration.
No, what we discussing the rights?
Which section of the act? There was a question about this.
Indemnify of the assets of the trust.
Right.
Remember we talked about it, if he had to pay for disbursements and all that, remember?
And then he could get it through the, but I don't remember which section of the trust act.
Oh, this, I see 58.
What 50,
Section 50 of the trust act.
what 50 say?
Remuneration of trustees.
Mhm.
If satisfied with the circumstances justify the order, the court may authorize a trustee, whether or not appointed by the court, to charge such remuneration for the services of the trustee as the court may think.
So what they said about this? Look on 50, look at 50. This is all in, this in 6 now. Look on page 50.
The court has discretion to allow. What's the question?
So we going above that.
Okay. It is important to note that only in exceptional circumstances may a fiduciary receive remuneration for his time and effort in acting in such capacity. As a general rule, trustees are not allowed to be remunerated for their work in relation to the trust unless they are authorized by the trust instrument. Therefore, trustees must ensure that the trust instrument also allows them to be remunerated, I guess, from the trust fund for reasonable expenses, e.g., out-of-pocket expenses incurred in the administration of the trust. Court does have discretion to allow remuneration or increase trustees' remuneration. Foster versus Spencer, 1996.
So what's gonna happen if you have disbursements and all that stuff, which you were supposed to do?
Charging
Yeah.
the trust fund, taking,
But what you had to do in order to do that?
Disclose it, eh?
You had to put it in what?
On
In
the
writing?
trust, instrument.
You're supposed to have it in the trust instrument to be able to do it. What the act provides? Insurance, eh? What the section is? We know that one good. Look on page 51. We put it on the side to say the trustee act, but then they tell you it. Yeah.
So just in case the trust instrument doesn't have it, that's why the trustee act has it.
The trustee act provides for what?
Insurance, as you said.
Right. Is that anything to do with your disbursement?
No.
No.
That's the power to insure himself against. So what they say you must do to get your disbursement,
Trustee.
right? What you have to do?
Make sure it's stated in the trustee.
So that's page 50, paragraph 3.
Okay, so.
Reasonable expenses incurred in thing.
Right. So, if the trust instrument does not indicate that they can be paid, this is why they have to go to the court.
They'll go to court, but then what happens in that instance? What the court supposed to be helping you with?
To get your expenses or expenses.
No, the remuneration different from the expenses.
So, what's your remuneration for work done?
Your
Eh?
time.
What's your disbursements? You gone and put yourself in bill knowing you didn't have the money. You didn't put it in trust document. So how you want to go and recover that now and you didn't put it in there?
Yeah, so you have to go to the court.
No, why you asking the court? What the act? What they said? They make any provision for you to get disbursement?
In the section 24.
No, what section 24 helping you with?
Remuneration.
No, insurance only. Against what?
Or breach of trust. So.
That's insurance, eh? Trustee Act 1998 gives the trustee power to insure himself against, except for breach of trust and the administration of trust. What that is? Against what? To insure themselves and their employees against personal liability and pay insurance premiums from the trust fund, except for
Breach of trust.
That's page 51. Because remember, you all had an issue with section 23. You all were saying section 23 was wrong.
And it was supposed to be, I think we confirmed the section 24.
Right.
Yeah, but okay. We started talking about remuneration. Then we jumped to.
That's the questions.
Expenses. Then we jumped now to insurance. So.
No, insurance is the statutory. I don't want y'all to mix that up with the disbursements.
Right, and that's why I don't want to be confused because I'm confused.
Okay.
So section 24 of the Act is just dealing strictly with the insurance for
personal
liability.
So don't mix that up with disbursements.
Right. So for disbursements can come from the trust fund.
Yeah, but
that has to be in the trust instrument.
Right.
If it's not in the trust instrument,
you lose on that one.
It's no way you can recover.
No, you spend the money without having that coverage. You must be know
So
what
that's
you was
your own personal money.
Right. Now, what you could perhaps do is include that in your professional fees. Try to catch it up there, and they don't have to know.
Be clear on.
But I mean, disbursement, the court never talk about disbursement, they talk about remuneration, eh?
Yes.
So you could attempt some of the questions and then we could do some more review on Saturday. Let's see what number 9 looks like. Number 9, babe. We could run through 9 quick and then answer some questions, eh? So we could know what direction we had in it. Yes.
Good night.
Okay, take care. Thank you.